questions, and then you can go back to the report.
Yes, yes.
If he was, could the panel also accept that it was no function of the Presidential Protection Unit to investigate the theft of money that Mr. Ramaphosa or his corporation may have suffered in its private capacity?
Well, let me go back to the report.
Sorry, it's a straightforward question.
Yes, yes, I am going to answer the question, but I do need to explain precisely the submission I'm making. So you go to page 137, well, 10 to 138. And you will find this everywhere, actually. 137, paragraph 238, and you will see there that the conclusion they reach is prima facie. You go to 138, 239, prima facie, and then you go to the charge 2, and you will find there the conclusion at 145, also prima facie.
But prima facie evidence. In other words, evidence which, if it is not answered, may establish the charge.
Yes. Well, it says in paragraph 264 where the actual conclusion is that this information discloses prima facie. So it's prima facie information, not prima facie evidence. So
all the panel can receive is information.
Yes, but...
Can I ask you, I'm breaking away from my sequences of propositions, but
yes.
You question the information about Namibia. Would you say that that would amount to evidence if the whole transcript and the whole audio clip was there as opposed to only part of it?
Well, there are two criticisms that were actually put by Minister Lamula. Number one is this criticism that unless you know the full chain, because you have, that's the one. The second one is distortion. In other words, it's information that is misleading. Even if it's evidence that is misleading.
Well, one doesn't know it's misleading. You say it may be misleading if you had everything else. All I'm saying is if you had a full transcript and a full audio clip as to part of it, as opposed to part of it, would you say that that would then be evidence?
Yes, if it was clear that it would meet some standard of admissibility. That's why they call it evidence. And no, it's not a court, it is a panel. But firstly, it must meet some threshold of admissibility. And secondly, it must not be cherry-picked. And those were the two criticisms.
Well, of course, we don't know it was cherry-picked. All we know is that perhaps it was what Mr. Fraser had.
Well, what we know is, if you can go to page 351 and 352, which is the analysis by the President of the information. (77.1, 77.2, 78, and 79. So you will see there that there is a problem about the incomplete nature. There is also a problem about the reliability.
But we must also take into account the, and it's been raised with you and your other colleagues by Justice Colopin and others, the panel is to some extent shoehorned into a process which must be finished within 30 days. It has no proactive powers to seek information. It simply evaluates information that has been given to it. But let's leave that to one side. I accept your proposition is that maybe the full transcript and audio clip would be evidence, but not just part of it. But anyway, if we can just continue. So,
well, Justice Rogers, no, I don't say that they should have got the full transcript. I say that if the panel wants to make a recommendation that there is a prima facie, there is sufficient evidence, it can disregard information that suffers from these defects and then only take forward that information that it would be satisfied would constitute sufficient evidence.
Or it may say, well, I've read what I've read in the transcript and I've heard what I've heard in the transcript. It may not be complete, but on what I have, it constitutes part of the evidence. But let me just carry on. So General Roeder was in the Presidential Protection Unit. It was no function of that unit to investigate the theft of President Ramaphosa's private money. and I assume you would accept it would be a serious abuse of power for the President to allow the PPU,
Sorry, Justice
as it
Rogers,
were,
I'm not waving at you. There is just a fly that is
Yes, no,
refusing. That is just refusing to.
I'm sure you're not trying to
refusing to
distract
disappear.
It would clearly be an abuse for a president to allow the presidential unit, protection unit, to, as it were, on the clock, use its to go and investigate a private theft. I mean, there could be no doubt about that, surely.
If you did so mala fide, as the required under the rules, and what also there could be no doubt about, whatever quibbles we may have as lawyers about the correctness or incorrectness of the Section 89 panel, the true question is members of Parliament acting rationally with the information at their disposal.
Yes. Now, I just want to find out for what there was and wasn't evidence. The next thing is, it seems to me to be common cause that no case of theft was ever opened in respect of this amount, which totaled in rands about 8.7 million.
Well, what we know is that he says, the president, I'm not acting for him, he says that he reported it to his head of security.
Yes.
And it was up to the head of security to open the case.
The head of a unit which is there to protect the security of the president, that has nothing to do with the loss of the president's personal money. That, I think, we must be, or at least the panel could assume that President Ramaphosa was aware of that distinction.
Well, I'm not sure I want to accept that he should be assumed to have been aware that if he reported to his head of security, it will not end up with the police. I don't think that is a fair assumption.
Well, it was common cause several years after the event that there was no case opened.
Yes, that is true.
Just put yourself in the position of the panel, or you yourself. Perhaps 8.7 million rand is not so much money to council these days, but imagine, I'm sure I'm being facetious. Imagine you had lost 8.7 million rand.
Let me not respond. No, Justice Rogers, I mean, this is unfair, actually. I know that it's not, but it's really unfair in a matter of this public importance to make a joke like that and then to pass it on.
Let me then continue. 8.7 million rand, if, just as a matter of common sense, if a person loses 8.7 million rand, they would want to know who the investigating officer is and has it been reported to the police. Is there a case pending? And it's common cause that there wasn't.
Yes. But what is the question then for the issue that I'm dealing with?
Now, I'm trying to just see the totality of circumstances.
Yes.
Then we have, and the panel paid a lot of attention to this, the source of the foreign currency, because it did, in regard to charges 2 to 4, it was not merely the fact that there wasn't a report to the under the Prevention of Corrupt Activities Act. It was the finding of seriousness was that that was a deliberate decision because the president was wanting to keep secret the source of the money. That is the background to where the panel was coming from. Now, in that context, it seems to me it was the president's version, based on what Mr. Ndlovu told him, that an unknown person, who is then identified as Mr. Hamaz, comes to the farm on Christmas Day, just happened to be carrying in cash $580 million, $580,000.
Yes.
Yes.
Yes, and then?
And then he concludes the transaction not with the farm manager, not with the man who runs the buffaloes, Mr. von Willich. He strikes a deal to buy 20 buffalo from the lodge manager.
Yes.
And hands over $580,000 and gets this receipt that we've seen. And then the buffaloes stay on the farm and are never taken.
Yes, I'm still trying to work out where, in relation to the members of the National Assembly, the criticism is.
Well, if there was sufficient evidence of the various matters I'm putting to you, then one might say that the independent panel could legitimately come to the view that in relation to charges 2 to 4, sufficient evidence of serious misconduct, sufficient in context to be tested for veracity, not sufficient to convict, but sufficient to go to an impeachment committee. That's what their function is.
No, I submit no, because they did not actually make that finding. What would actually happen if we got where you are, Justice Rogers, is you would have to fundamentally rewrite the conclusions of the panel. That's why I was asking the court to have regard to there are actually several pages, 128, paragraph 204, 137, paragraph 238, 138, paragraph 239, 145, paragraph 264. It's so clear in those paragraphs that what they thought they were doing is to establish prima facie evidence based on information.
Well, we will read the whole report. You'll recall, I think, the acting Deputy Chief Justice put to, I think it might have been to Mr. Budlander, certain earlier paragraphs which appeared to indicate what the panel understood. But I accept, bear in mind, the panel here says, even after hearing the President's version, taking into account what he says, this is not just yet unanswered evidence. Together with his evidence, we take it that there is prima facie evidence. But if you say that that was the wrong test...
Yes. So, in fact, I think we are together, the criticism. If you want me to comment, let me know, Justice Rogers, if you don't want me to comment on the two paragraphs that Justice Madlanga referred to.
Perhaps let me just finish and then you can come back and comment on those two paragraphs. Yes. We then find that the $580,000 is not put into a safe, and I would have thought more importantly, it is not put into a bank where it would have earned interest at about 2,300 Rand per day. The first thing anybody who receives 8.7 million Rand wants to do is to make sure it goes into their money market account. You don't leave that much money, sorry, I'm now speaking as a matter of common sense. You don't just leave that money either in a safe or under a sofa. I'm not talking about, it's common cause that it wasn't banked and it was hidden in a sofa.
Yes, well, the question is, what is the role of the members of Parliament in relation to what the President knew at the time?
Well, if they read the whole report, because the structure of the report is before the committee starts dealing with the individual charges, which starts at paragraph 181,
yes,
where it starts with charge 1. It's had what seems, in the context of its report as a whole, to be a very important chapter 12 that runs from page 89 through to 173, including the conclusion in paragraph 171. And that's all to do with the source of the money. And it is clear from the panel at least believed on the information that had been submitted to it that it did not accept that the money had come from the sale of buffalo.
Yes, just now, sorry.
And then, having considered the individual charges, it then in chapter 15 deals with the seriousness of the violation and the misconduct. And it is at that point that it ties in chapter 12 with charges 2, 3, and 4. To reach a conclusion, call it a prima facie conclusion, yes, that the reason why there wasn't a report to the DPCI and the reason why a case wasn't opened and the reason why General Roeder, as it were, off books, conducted an investigation and into the theft was because the source of the money was not legitimate. There was an attempt being made to conceal that was the case.
Yes.
Now, I assume you accept that if there was, let's just say, prima facie evidence of that, that would be prima facie evidence of extremely serious misconduct.
Yes, I have no difficulty accepting that at all.
And do you say that there was prima facie evidence of that, but not sufficient evidence?
Yes, no. Yes, I think this is where you and I, Justice Rogers, do not seem to be getting what I'm trying to say. I am saying the finding that must be made by the panel is sufficient evidence. If the panel erroneously fails to make that finding, that is sufficient to vitiate its report. And that is why I've taken the court to where the panel makes that finding. So my primary point is, from the perspective of the MPs that were voting on the report, what they needed to look at, which is what was debated, did the panel act in accordance with its terms of reference? Its terms of reference required it to conclude sufficient evidence. Did they do that or not? They came to the conclusion that it didn't. And on that basis, they said we could not correct an illegality with another illegality. We would vote down the report. Now, it may be that one day, in a criminal case, the president will have a case to answer. It may be that one day, in a different case that comes before the National Assembly, the ANC will take a different position. But on this report, in these findings, the National Assembly was perfectly rational in arriving at the decision that it did.
Now, the expression prima facie evidence does still refer to evidence, but you say the fact that it is prima facie stands on a different footing from its being sufficient.
Indeed.
Now, in the context of the report as a whole, if one reads what the panel regarded as the evidence, and you say, but it formulated it as being merely prima facie, but if you look at that evidence and you say that although it called it prima facie, it was within the context of its function under Rule 129I sufficient, bearing in mind that it's not, as you have said, a veracity exercise. The context is it enough to go to an impeachment committee? What would you understand the precise difference to be between, let's assume for the moment it amounts to evidence. It amounts to prima facie evidence as opposed to sufficient. What do you say is the lower test which has been impermissibly slipped in?
The distinction is better explained by reference to the rules themselves. If you go to page 631, at Rule 129A, and 129A 1 sub A.
Sorry, 1?
129 capital A brackets 1 small a.
Yes.
So the rule itself tells you that when the Speaker decides whether or not to constitute a Section 89 panel, she must already apply her mind to whether the charge sheet contains prima facie, what discloses a prima facie case against the President. But that changes fundamentally when you go to 633. Sorry, no, it should be 630.
Whether sufficient evidence exists.
Yes, whether there's sufficient evidence that exists.
Yes, sorry.
Yes. Now, what that means is that it is not up to the court, and it is not up to the assembly. It is up to the panel to come to the conclusion that sufficient evidence exists. That's number one. Number two, we know here, we don't speculate, we know precisely here that they did not intend to do what you are suggesting, Justice Rogers, because they specifically debated the difference, and they ultimately came to the conclusion that there is no difference.
There is no difference.
There is no difference. That is the conclusion.
Yes, but that was my question. What is actually the difference? Bear in mind what the Speaker does when she or he vets the motion is only looking at the evidence put up by the party moving the motion. That's the only evidence at that stage.
Yes.
That's one side.
Yes.
By the time it gets to the independent panel and it reaches its conclusion after it's gone through all the processes it must go through, it has also heard the President's version.
Well, we can...
And now the question is, in the light of all, and bear in mind, it is no longer the Speaker who is, as it were, doing a first cut, and the Speaker may with due respect to her or him, not have any legal qualifications.
Yes. No,
That same evidence, plus any additional evidence that has now been placed before the committee, plus the President's response to it, all of that, is there sufficient evidence? Now, all of that has been considered. Now, in the context where you have not now only heard one side, but you've received additional information supporting the motion, and you've received additional motion against it from the President. Yes. Now you say, in the light of all of that, the formulated test is sufficient evidence. But what I want to know is, what is a lawyer conveying when they assess all of that evidence and they describe it as prima facie evidence rather than sufficient? What is the qualitative difference that you would then understand between those two formulations?
Well, the first thing we would know for sure is that they did not do what they were asked to do, which is to consider whether there is sufficient evidence. We know that as a fact. They specifically disregarded their terms of reference. And in fact, Justice Rogers, you're reminding me of something else. We found the actual terms of reference. They are in the SLA. We tried to submit them. There is an objection from the EFF. But it's important for the court to know the actual terms of reference that the panel had. If the court is interested, we would be happy to circulate those, but we've now got them. So we know for a fact that they disregarded their mandate. They were told they must find, positively find, not hide it in another language, positively find. And that is because, and this is important, that's why it's not a terminological problem. It's important because you are going to send this to lay persons, 400 of them, and you are going to ask of them to make a decision. And what they will have in front of them is they will have the terms of reference they gave you and your report. The first thing that will be glaring is that you disregarded what they asked you to do. And so when you are going to vote on it, about whether you need to proceed with this or not, the first thing that will strike you is that they disregarded the instruction that we gave to them. There is a different question, an analytical question among lawyers, which is, what is the legal distinction between the two? Now, the answer to that is that that distinction is foreshadowed by Parliament itself by making sure that the Speaker and the panel do not ask the same question. They ask different questions. And on the evidence, the question is, what did the parliamentarians understand the difference to be? What did the parliamentarians understand the difference to be? Now, on that, we have two sources. One, we have Minister Lamula's statement, which is 956A to 956F. What he says are the problems which distinguish information from the evidence. He says, number one, and you can, it's 956C. He says the first problem is the so-called conflation of information and evidence. And he explains that evidence and information in law are two different things. Information is knowledge obtained from investigation, study, or instruction. Evidence is what is legally submitted to a tribunal to ascertain the truth of a matter, and it must have passed the admissibility test. Furthermore, there is no analysis in the report which shows how the information which was provided to the panel was converted into evidence. He goes further.
Sorry, but if I can just pause there, at least Mr. Badnada understood to not embrace the notion that sufficient evidence has any connotation with what's presented in a form that's admissible judicially.
Well, we would submit that it must at least pass some standard. I mean, if, for instance, as I'm making the example of an incomplete statement, it's an incomplete statement. You have no idea what is the name of the witness. You have no idea where was it signed, where was it obtained. It is information, and it may contain crucial information.
See, I did a search of the phrase sufficient evidence in the statutes. It's used many times, and it's very frequently used completely unrelated to what might be admissible in a court of law. For example, in regard to BEE status and qualifications, has the person submitted sufficient evidence of this or that? There's even a reference to, is there sufficient evidence to make out a prima facie case? That also appears in the statute. an auditor must audit to establish sufficient evidence of something. You must submit a bank statement to the master or some other sufficient evidence. We're not talking necessarily about anything that's admissible in a court of law.
Yes. No,
So a document might be, even if it's not proved through the author of it, might be sufficient evidence or part of the evidence.
yes, or it may be so unreliable that it should be disregarded because it would not even pass the threshold of evidence prior to its sufficiency. And this is what Minister Lamula said at the time in the meeting, because that is the true test, is what did they understand the difference to be, and can you impugn their understanding of that difference? So it goes further because it shows that there is a qualitative consequence. It was not just about text.